Hey, greetings. I'm delighted to welcome you all to the second webinar in this year's A4ID series, Justice Through Partnership, Unlocking Legal Support for Development Impact. I am Yasmin Batliwala, the Chief Executive of Advocates for International Development, or A4ID. Today, we turn our focus to a region that holds immense promise, resilience, and potential, and that is, of course, Africa. And also to a question that we want to address that lies in the heart of our collective mission. And that is, how do we build partnerships that strengthen the rule of law, uphold justice, and deliver equity and sustainable progress across this vibrant and diverse continent? Africa is, after all, a continent of extraordinary possibility. It is home to the youngest population in the world, has abundant natural resources, and some of the most innovative responses to the great challenges of our time, from climate change to digital transformation. Yet we cannot overlook the systems and the structural injustices, fragile legal systems, inequities that continue to hold back millions of people from realizing their rights and living lives of dignity and opportunity. The rule of law is not just a legal concept, it is the very bedrock of development. When laws are fair, accessible, and enforceable, they create the conditions for businesses to thrive responsibly, for governments to be held accountable, and for citizens to seek redress when they're wronged. Where the rule of law falters, however, so too does trust. Trust in institutions, trust in markets, trust in each other. And that is why partnership is so vital. No single actor, no government, no NGO, no company, no lawyer can solve these challenges alone. But together, we can forge pathways that none of us could create in isolation. Together, we can create a world where the law is not a barrier, but a bridge to opportunity, a bridge to dignity, a bridge to a just and sustainable future. At A4ID, we see what happens when legal expertise is matched with local knowledge and lived experience. We've seen businesses work with communities to design frameworks that respect human rights and protect the environment. We've seen lawyers stand shoulder to shoulder with civil rights society groups, helping them navigate complex legal landscapes to demand accountability. And we've seen innovations in legal technology open doors to justice to people who were once locked out. So in today's discussion, we will explore these very themes: responsible business, strengthened rule of law, and innovative access to justice leadership partnerships. This is not just about achieving SDG 16, peace, justice, and strong institutions. It's about enabling every other sustainable development goal. Without justice, development cannot be inclusive. Without equity, progress cannot last. And without partnership, neither justice nor equity can take root deeply enough to transform societies. So as we open this session, I invite you to approach today's discussion not simply as a learning opportunity, but as a call to action. Ask yourselves, how can we use the law more creatively and courageously to address injustice? How can we hold ourselves accountable as partners, ensuring our collaborations are equitable and driven by local priorities? And most importantly, how can we leave this conversation with a renewed commitment to turn words into action so that justice is not just promised, but delivered, and delivered for everyone? Let this session remind us that the arc of justice does not bend on its own. It bends because people like all of us in this webinar, in this session, take hold of it and refuse to let it go until it points towards fairness, dignity, and hope. So can I say thank you for joining us today? Thank you for bringing your expertise, your insight, and your passion into this conversation. Together, let us use this time to inspire one another, to forge stronger partnerships, and to ensure that Africa's journey towards justice and sustainable progress is not delayed by lack of will or imagination. Because the future is not something we can wait for, it is something that we build together. Today, we have an outstanding lineup of distinguished speakers who will share their insights and their vision for how partnerships can drive change. So it is with my greatest pleasure that I introduce our moderator, Dr. Joseph Bayomuhangi, who will take us through this webinar session. Joseph is a Ugandan legal and policy expert with extensive experience in business and human rights, corporate accountability, and access to justice in Africa. He coordinates the Uganda Consortium on Corporate Accountability, which is a civil society coalition that promises responsible business conduct, human rights due diligence, and access to remedy for affected communities. Welcome, Joseph, and over to you.
Thank you so much, Yasmin, for setting us up this conversation for the next hour. I'm very happy and enlightened from the opening remarks you've given for our webinar on partnerships, anchoring law as a bridge as opposed to it being a barrier when it comes to partnerships for justice, equity, and sustainable progress on our continent, Africa. As the conversation is going to flow, we have Patrick Karanja from FYD to be able to take us through their overview, the work they do, and then once he's done with sharing the context of partnerships on the African continent, we'll then have to listen in from Shirly Amayo, a fellow at death penalty, Reprieve in the UK, who will share with us rule of law as a catalyst for accelerating progress towards achieving sustainable development in Africa. And subsequently, we will have Miss Leonie Mutoni, the Director of Programs at Legal Aid Forum in Rwanda, and she'll be discussing with us access to justice, sharing particularly the innovative strategies towards strengthening rule of law and deepening access to justice on our continent, Africa. I encourage the participants on the call to share their questions in the chat such that we're able to have our speakers respond to them. Over to you, Patrick.
Thank you, Joseph, our moderator for the day, and also thank you, Yasmin, for setting the context and framing the conversations that we'll have over the next 1 hour. My name is Patrick Karanja. I work with FYD as the Project Lead Africa. I am based in Nairobi, and I coordinate FYD projects and activities in Africa. I'm very much privileged to share a highlight of the work that FYD has been doing in Africa for the last 7 years. We have in particular been working in collaboration with national bar associations in East Africa. This includes the East Africa Law Society, the Law Society of Kenya, Uganda Law Society, Tanganyika Law Society, Rwanda Bar Association, South Sudan Bar Association, and Burundi Bar Associations. We've also been working in other countries outside East Africa on rule of law strengthening projects in partnership with other organizations. I wanted to highlight 3 strategic and thematic areas of focus that FYD has been working on and partnering with organizations in Africa. And the first, you may have interacted with us in business and human rights training for commercial lawyers and in-house counsels in East Africa. That was our flagship partnership activity with national bar associations. We have held various webinars and in-country conferences, and our aim was to engage the legal community, particularly in East Africa, on conversations around the UN Guiding Principles on Business and Human Rights, recognizing that lawyers are critical players and a catalyst for social transformation, and also recognizing that whether it's in-house counsels, whether it's commercial lawyers, we are the first point of contact for companies when they need to be advised on their operations and how these operations will potentially interact with people, communities, and environment. Therefore, lawyers play a very critical role in ensuring that companies not only ensure they take into consideration responsible business practices in developing their policies, but ensuring as much that when business operations cause adverse impact on human rights, that companies can take the lead in ensuring there is effective access to remedy for those adversely impacted by a business operation. And I think this is really timely and important, particularly in East Africa and Africa, as Africa is fast becoming attractive to foreign direct investment, and as is considered as one of the fastest growing economic blocks. If you look at most of the top 10 fast growing economies, about 11 or 12 are in Africa. This means that Africa, as the next frontiers for investment, will be juggling with discussions on how do we ensure investment not only contribute to development, but also the safeguard for human rights for people, communities, and the environment. And at FYD, we recognize that business and human rights being an area of practice, particularly for the global law firms and our legal partners in the UK, we wanted to create a partnership where we could have peer-to-peer learning between the legal community in the UK and the legal community in Africa, to have discussions on how does business and human rights look like, what is the obligation and the role of lawyers in ensuring there is responsible business conduct, and that investment in Africa not only contribute to development, but also uphold the dignity of the people. And in addition to the collaborations with the bar associations in delivering business and human rights training, we are also currently collaborating with the judiciary, case in point, the Kenya Judiciary Academy, in a partnership with the Danish Institute for Human Rights, to engage judicial actors and judges and magistrates to sensitize them about the UN Guiding Principles on Business and Human Rights. And this is in recognition of the fact that even though we have done a lot in capacity building for the legal community, we need to make sure that these conversations on responsible business are also in the judicial system, so that judicial actors can also be key stakeholders in ensuring that corporate responsibility to respect human rights become a reality. In partnership with our leading law firms in the UK and other global legal experts, we have developed a 4-module e-learning on business and human rights for lawyers, with the first module looking at international, regional, and national frameworks on business and human rights, and another module, module 2, looking at human rights due diligence, module 3 looking at ESGs and how lawyers can incorporate this consideration to ensure there's responsible business practice, and also looking at business and human rights as an emerging area of practice for lawyers. We will provide a link to our e-learning on BHR so that you can, it is a self-paced course that you can engage in. And this is developed in collaboration with global legal partners and also our in-country legal experts. The other thing we have really worked on is with the national human rights institutions and the departments of justice, partnering towards supporting development and implementation of national action plans on business and human rights, particularly in Kenya and Ghana, where FYD has been actively participating in the development process on the NAPs. And we urge lawyers, I think our experience was that in most of the processes of the development of the NAPs, especially commercial lawyers and in-house counsels and national bar associations, may not have sufficiently contributed to the agenda, but I think it's a ripe opportunity for lawyers to reclaim our role to work with other stakeholders in country on conversations on development of the National Action Plan so that we can leverage our legal expertise to ensure there's responsible business conduct and that we can support communities to effective access to remedies. Another area of work for FYD is coordinating pro bono legal assistance, where we engage lawyers in promoting culture of pro bono and connecting lawyers to provide pro bono legal assistance to NGOs, civil society organizations, and social enterprises. Based on the conversation from yesterday's webinar, it is now a reality that, especially post the USAID withdrawal funding for many organizations, and also the reduction in overseas development assistance, lawyers will play a critical role in supporting nonprofit organizations, in addition to our traditional access to remedy and public interest work, to ensure that we support small organizations so that they can be resilient, so that they can renovate themselves for sustainability. At FYD, we have the Pro Bono Legal Services team that works in connecting lawyers with civil society organizations to provide pro bono legal support. We will leave a link in this webinar platform for you to be able to see what our pro bono legal services look like and to engage with us. Finally, we also coordinate partnerships for strengthening rule of law with various government entities, regulators, and civil society organizations through our Roll UK program. So in essence, and as I conclude, our lesson is FYD has been that the work before us cannot be done by one entity, and we therefore call upon lawyers, whether you are in-house counsel, whether you're a commercial law firm, whether you are a CSO, whether you are national human rights institutions or state counsel. If we can collaborate and seek opportunities for partnership, together we can achieve more in ensuring that we not only deepen access to justice, foster equity and human rights, but also strengthen rule of law in Africa, so that we can be able to make an Africa where development upholds the dignity of our people and leads to justice for all and sustainable development. And with those few remarks, I want to hand this over to Joseph, our moderator.
Thank you, Patrick, for shedding light on FOD's work on the continent and emphasizing the need for partnership across board. All lawyers need to put hands on the deck for us to be able to achieve partnerships for justice, equity, and sustainable progress on our continent. It's now my singular honor to invite Shirly Amayo, to be able to speak to us on issues of rule of law as a catalyst for accelerating progress towards achieving sustainable development in Africa. Shirly, over to you.
Thank you, Joseph. Thank you, Yasmin. Thank you, Patrick. Yes, I'm Shirly Amayo from Reprieve, UK, working on the Kenya resentencing project. So by way of introduction, Reprieve is an international human rights organization working on various issues. One being to end the death penalty, where we support prisoners facing execution, pursuing legal reforms, as well as promoting alternatives like resentencing. We also challenge unlawful detention, advocating for those held without due process and campaigning against torture and indefinite detention. We also expose abusive counterterrorism practices, from extrajudicial killings to rendition, while demanding accountability from those governments. And finally, we also do a strategic litigation and advocacy towards abolishing the death penalty, as well as partnering with local lawyers and communities to strengthen justice systems. So basically, Reprieve defends people who actually need it, people who face grave abuse of state power, torture, unlawful detention. But today, I will focus specifically on our work in Kenya, on the Kenya Resentencing Project, where we work around resentencing of individuals who were condemned under the mandatory death penalty. So in Kenya, we know that the death penalty is a legal sentence, and for decades, Kenya maintained a mandatory death penalty for capital offenses such as murder, treason, robbery, violence. And what this meant was that the judges had no discretion once one was convicted of these offenses, that the sentence will definitely be murder, regardless of the circumstances, regardless of the mitigating factors. However, in 2017, the Supreme Court of Kenya, in the landmark judgment in Muratetu, declared the mandatory death penalty unconstitutional, which opened doors for thousands of individuals to seek resentencing. At the time, there were about 6,000 people on death row. And so this particular judgment that declared the mandatory nature of the death penalty unconstitutional enabled those people to actually file for a sentencing and have their sentences reviewed based on the mitigating factors. However, there were challenges at the time. Many of those eligible persons had been incarcerated for decades, so they had little to no access to legal counsel. And without representation, they could not effectively argue for themselves in terms of resentencing. The applications that they were filing were really not great, and they were also not highlighting the mitigating factors that they needed to highlight to enable the judges actually give them favorable judgments, or rather to give them a just ruling. So what we're saying is that Muratetu ruling was an opening for justice, access to justice for people who had been forgotten by the system. But then the promise of justice reform risked being lost without lawyers actually carrying it forward. And so Muratetu in itself had a number of outcomes. And one of the outcomes that Muratetu had was, of course, strengthening rule of law in practice, because the ruling enforced the constitutional principles that all laws and state actions must align with the Bill of Rights. And by striking down the mandatory death penalty, the court emphasized on judicial independence, fair trial rights, and proportional sentencing. So this outcome, of course, signified or signaled that constitutional safeguards are enforceable in practice, thereby strengthening the rule of law in Kenya. Another outcome, of course, was the protection of this vulnerable group. The vulnerable group here being people on death row, because this decision immediately benefited these individuals on death row, many of whom came from marginalized and disadvantaged backgrounds. If you've had an opportunity to look at, for instance, the survey that KNCHR did a couple of years ago on people on death row, most of them are really from marginalized community and disadvantaged backgrounds. So in essence, criminalizing poverty. So by requiring individualized sentencing, the courts provided an avenue to consider the mitigating circumstances that each of these inmates had, their age, their socioeconomic status, mental health, and other issues such as gender-based violence. And this, of course, enhanced the protection of these vulnerable groups who might otherwise face disproportionate punishment. The judgment also prompted the judiciary and other justice sector actors to initiate sentencing guidelines. At the time, as Reprieve, we went to different courts, different prisons, to speak to the inmates as well as the judiciary to see how exactly the Muratetu judgment was being implemented. And we found that there were a couple of challenges. Some courts were sentencing the inmates, some were not resentencing the inmates, and some stated that, because the death penalty is still a legal sentence, really, unless something changes, there's nothing they can do. And so this, of course, initiated the process of having a framework for resentencing hearing, which as Reprieve we were also privy to, because based on the challenges that we found, we put it down and presented it to the NCAJ. And since they were reviewing the sentencing guidelines at the time, they were able to include this, the resentencing guidelines in the sentencing guidelines that were gazetted 2 years ago in 2023. In terms of the long-term impact of the Muratetu ruling, we know that the ruling has entrenched constitutionalism by demonstrating that courts are willing to strike down laws that are inconsistent with the Bill of Rights, and it has fostered, a stronger culture for rights protection, enhancing respect for judicial authority, as well as the gradual shifts in terms of prioritizing human dignity, equality, and fairness. We can also see it as a pathway towards abolition of the death penalty. There are so many places where it started from resentencing and then gone to abolition. So this ruling, of course, it did not abolish the death penalty outright, but since it has weakened its application by removing the mandatory character, it has created a jurisprudential pathway to abolition. So at Reprieve, the Kenya Resentencing Project has had a number of, the initiative was built on a number of pillars. And the first one is onboarding pro bono advocates. So in the first instance, when we went around, we collected data of those who were on death row at the moment, and subsequently, most of them have been commuted from death to life, and we have the information of these inmates. And so the first stream of work that we had was onboarding pro bono advocates, so that the advocates who are willing to actually dedicate their time and skills to represent these inmates at no cost. And not only have we onboarded a couple of advocates in Kenya who are actually currently helping us to represent some of these inmates, we also work, or rather have technical support from other pro bono law firms, such as Linklaters, who have helped us draft applications or submissions for clients, as well as develop template documents and petition submissions, and created a database where we can map out the clients who need representation. So it was the joint effort itself in terms of advocates, local advocates, and the technical support from pro bono firms based in the UK. And so this has, of course, we ongoing cases, and we have, at least so far, we already have 2 inmates who have been released based on this work, and the others are still ongoing. The other pillar of work is capacity building. So we have trained advocates on drafting, persuasive sentencing submissions, as well as investigating and presenting mitigating factors by adopting, of course, client-centered approach based on each inmate. And then we have also trained judges on how to handle resentencing matters to help crystallize the latest resentencing practices, especially best practice in the Kenyan context, because there's been shifting jurisprudence and different school of thought. So we ensure that they are well aware of what the resentencing guidelines entail, and what mitigating factors, how to identify these mitigating factors as well. We've also trained probation officers because they do draft the victim assessment reports as well as social impact reports, which are presented during the resentencing applications. There are also prison paralegals, and these are inmates who are trained paralegals based in prisons. We also have trained them on resentencing. We've taken them through the resentencing guidelines, as well as prepared a submission template that they can use. We would like all the inmates, of course, to have counsel, but then at the moment that is not possible. So for that is why we developed these template submissions that we trained the prison paralegals to use when they are assisting their fellow inmates to draft the applications. In terms of the advocates that we have onboarded, we also conducted a training for them as well. And the main objective of that training was to build their capacity as pro bono lawyers to handle resentencing matters, share best practices in presenting mitigation, such as mental issues and other mitigating factors. And so from this we can say that it's collaboration is necessary, that we need all this aspect. We need to have all these people involved so that the initiative is not only ad hoc, but it's sustainable, scalable, and also impactful. And so what with the role of the lawyers, of course, in driving a change, and especially for us in the resentencing process, is because when we speak to the inmates, they had lost hope. Our pro bono scheme is, of course, they always say is, they're overworked and underpaid. But when the lawyers assist, especially this pro bono advocates assist these people, we find that it sort of restores their dignity and hope, because these inmates have already lost faith in the justice system. So having a lawyer beside them signals that their lives still matter. And then the lawyers also help in accountability and fairness, because the lawyers are interrogating the sentencing disparities, challenging the arbitrary outcomes, and of course bringing systematic change. Other than that, again, lawyers are very instrumental in building jurisprudence, because each resentencing case contributes to a body of law that refines the sentencing principles in Kenya, whether it's when it's in regards to the mitigating factors that have been presented, lawyers' arguments on proportionality, dignity, and rehabilitation slowly shifts how justice is understood and applied, and focusing on those mitigating factors such as gender-based violence that have not previously been taken into account by the courts. It is really allows such considerations to guide the decisions of the court. So building jurisprudence is really important. And one of the key jurisprudence that we can highlight in this is the Trufena Swani case, where gender-based violence was considered during that judgment, and Trufena got a sentence of 1 day. So the question that maybe we can ask ourselves is, what does this mean for the rule of law? Resentencing demonstrates how the legal systems can adapt to the emerging challenges. It ensures compliance with the Constitution as well as human rights standards, and it alleviates systematic issues, even like prison overcrowding, because most of these people really do not, and we're not saying that people are not supposed to be punished. Yes, people should be punished, but the punishment should fit the crime. So in most of these issues, it has a direct impact on the socio-economic benefits for the states. It also aligns, of course, with the global development goals, but particularly on reduced inequality, peace, justice, and stronger institutions. Therefore, what I can conclude by saying is that lawyers are not just practitioners of law, they are the architects of justice. So through pro bono commitment and collaboration, they extend justice to a society that has been forgotten. And in this case, inmates who were sentenced to death in this country, especially where we do not execute. So they are in prison and indefinitely. So we are here today because, in my belief, the rule of law is under threat in this society. So when a justice system is weak, and rights go unprotected, of course, corruption will thrive and inequality deepens. So civil society, just like ourselves, are fighting for change, but then we face a critical gap, and we need legal expertise to turn the law into a tool for transformation. And lawyers possess the unique power to strengthen the rule of law, because lawyers bring more technical skills, drafting the laws, navigating the court, dissecting the regulations. Therefore, lawyers are really, really, really important. And lawyers carry credibility with institutions and communities, and strategic vision to turn actually the legal frameworks into engines of justice. So where activists highlight problems, then lawyers will technically be the engineers of the solution, whether it's through amending the flawed policies or holding powers accountable, basically empowering the marginalized voices, because lawyers not only interpret the law, but they have the power to actually reshape it. And as I conclude, I would just conclude by saying that lawyers, or rather encourage our colleagues in the legal profession to embrace pro bono work, not just as charity, but as a professional duty to form and as a form of accountability to the society we serve, because justice is not justice if it's not accessible, and lawyers hold the key to making it accessible to everyone. Thank you.
Thank you, Shirly, for speaking to the pivotal role of lawyers in ensuring that we have rule of law. And right about this time, I'll hand over the mic to Miss Leonie Mutoni to be able to speak to access to justice by sharing the innovative strategies towards strengthening rule of law and deepening access to justice across our continent. Over to you, Leonie.
Thank you, Joseph. Am I audible?
Yes, you are.
Great, thank you. Good morning, good afternoon, everyone, wherever it is you're joining from in the world. My name is Leonie Mutoni. I work with the Legal Aid Forum. I'm the Director of Programs and currently based in Kigali, Rwanda. So I want to thank FYD for organizing this very important conversation, and I am honored to both contribute and learn. So I have prepared very few slides that I'm just going to go through as I share about today's topic, justice through partnerships, but specifically a case study of the Legal Pro Bono Rwanda project, which the Legal Aid Forum implemented with the support of FYD. Yes, so I think it goes without saying that access to justice is a fundamental right without which no society can achieve any meaningful development. You can imagine a society if somebody faces a legal issue or even their rights are violated, but there is nowhere they can get help, or if it exists, it's a system they cannot afford to navigate. It's a major problem. There cannot be any sustainable development. Yet, despite this, over 5 billion people worldwide, very staggering number, this huge number of people live with unmet justice needs. And this shows that there is a significant violation of human rights, but also a major obstacle to the rule of law that Shirly explained so well. And we have found that generally the key barriers tend to be the same. They include high-cost legal services, lack of awareness about rights, geographic remoteness in some areas, and the complexity of the legal system itself. And so it highlights the need for conversations like today, innovative solutions, partnerships, and all of that. So that's what our work is about at the Legal Aid Forum. We are a non-profit, non-governmental organization working in Rwanda. And our mission is really to advance access to justice specifically for vulnerable communities in Rwanda. And of it's usually vulnerable communities, unfortunately, that face the biggest barriers in affording or accessing access to justice, which is why we decided to focus on that group. So think refugees and asylum seekers, elderly persons, GBV victims, persons with disabilities, LGBTQ, etc. So we support them, or rather support access to justice for them through provision of direct legal aid services, but also advocacy around legal frameworks so that we can have people-centered justice reforms. With that background, I will very briefly talk about the specific projects that we implemented with the support of FOID, which honestly, it was, I think, partnership in action because it was a number of organizations working together and local authorities, and we were able to bring about some good impact. So it's a project that we implemented from November 2021 up to March of this year. And I should have mentioned that the Legal Aid Forum is a membership-based network. So it's different NGOs that work to advance access to justice that came together and then formed the Legal Aid Forum. And we're currently the leading non-state legal aid service provider in Rwanda. So for this project, it was implemented by the Secretariat, but also 3 of our member organizations. And we focused on the capital city of Kigali as a pilot project. And we focused on 3 major work streams. So strengthening the CSOs to deliver legal aid, fostering partnerships with law firms to promote the culture of pro bono, and also reinforcing university legal aid clinics. And just to give you an overview of the project's reach or impact, we were able to do lots of legal education. That is something that is important for all the members of the Legal Aid Forum, and it goes without saying, if people don't know their rights, they're unlikely to claim them. So legal education was a big component of this project, and we used many channels in order to reach people. So we used community outreach. Every month throughout this project, we were going out in communities with the CSOs and our community-based paralegals, even university legal aid clinics, to raise awareness on rights. But we also used media. So radio is commonly used in Rwanda. If you want any form of information, you're most likely going to get it from radio. So we leverage that as well. And our own ICT platform that the Legal Aid Forum has, which is basically a call center where people can call and either speak to a lawyer or listen to pre-recorded legal content. And it's kind of a fun way to learn about the laws. So in this project, we also did a lot of legal representation. We were able to do legal representation for about 694 cases. And I want to stress that this is the work of us, the Legal Aid Forum, but also our 3 members. But we were able to reach these numbers because we also partnered with private lawyers and law firms, which I will get into a bit more into this presentation. But we did legal representation as well as the legal advice. And I think the numbers can speak for themselves. So going more into details of the partnership with the law firms. So with this project, we had kind of an innovative model, really, because in Rwanda, the Rwanda Bar Association does require lawyers to take at least, I think, about 2 pro bono cases each year, but it was not very common for CSOs to form partnership with law firms. So this is something that we were able to do with this project, and we found that it actually improved the perception that people had of pro bono as a service itself. And so in this project, our 3 organizations were able to partner with about 16 law firms, and they work together with these law firms whereby they would refer to them cases that need legal representation, because we know law firms have these resources. And it was especially important because in Rwanda, legal aid is not funded by the state. So legal aid services are usually provided by CSOs, non-governmental organizations. So being able to work with law firms also was a way to help us expand access to these legal services through our project. However, there was still a bit of a challenge in distinguishing between pro bono legal aid, pro bono services and legal aid services. And we're still engaging law firms even after this project to kind of continue the momentum of that culture, so to speak. I mentioned that this project also supported local CSOs. I liked what Yasmin said in her opening remarks. It's true that not one single actor can fix all the issues that there are. So we have to partner. And in this project, in addition to partnering with FOID, who provided the financial support, we also had our 3 member organizations who were implementing activities in communities. So they were doing a lot of legal education and awareness. They're providing legal advice and mediation, even legal representation for cases that required it. And speaking of partnership, they had to work with local authorities in order to, first of all, allocate time during monthly community gatherings, which is something we do often in Rwanda. Every week there's like a citizen assembly. So you have to work with local authorities to kind of have a spot during those meetings and use it as an opportunity to teach people about their rights. So CSOs did this. And another interesting thing is that they also partnered with university legal aid clinics. And it was an approach that was successful because students had not really been consistently engaged in similar efforts of providing legal awareness. And of course, as law students, it is their hope that they will be professionals, legal professionals in the end. So with this project, we were able to expose them early on, both to having a pro bono culture, because they were actively providing legal assistance to vulnerable people. But it had to be law students who are in universities that have established legal aid clinics. This was not very hard for us to do because Legal Aid Forum also has university legal aid clinics as part of our members, so we worked with them. And as I come closer to concluding, because we also talked about innovative strategies to expand access to justice, I wanted to highlight this really important innovation that, again, the project helped us to sustain. So it is our legal aid call center, which is accessible nationwide, free of charge. And it is something we established back in 2018, when after we had conducted a study to gauge citizens' feedback on the delivery of justice systems. So we found that a lot of them, the biggest barrier was distances that people had to travel. So you would find someone who has to travel, let's say 6 hours of the day, just if they're in remote areas, they would have to travel up to 6 hours just to get to the nearest legal aid service provider, sometimes only to get there and find, you know, maybe you should have gone to a different office, or maybe you should have called first, or we're not open today, whatever the reason. And this person has spent the whole day traveling. If they're in the informal sector, which is the biggest in Rwanda, that means they didn't work all day, they didn't make any money, yet they spent a lot of funds trying to access justice that they don't get in the end. But another big barrier was also the fact that people don't know their rights. I think we had about 1,000 people who participated in this research, and only 4% marked their knowledge of the law as moderate. So we had to come up with an innovation to give people legal services without requiring them to travel long distances. So that's exactly what our call center does. Anybody from the comfort of their home can call and speak to a lawyer. And also, if sometimes the issue will be resolved if they need maybe just orientation, but if it's a bigger issue and our lawyers in the call center realize that this person needs legal representation, that case is escalated and then the person is assigned a lawyer. And I mentioned, I think earlier, that in addition to this speaking to the lawyer, you can also call and listen to just pre-recorded legal content on a bunch of laws. It can be on GBV, on land rights, on freedom of expression. And so in our project, by the time FOID came on board, our call center was resourced. So we had fewer people calling, and it was not delivering services as we wanted. But with the support of this project, this very important partnership, we were able to upgrade and sustain our call center, and it continues to effectively give people legal services from the comfort of their home. So as I wrap up, I wanted to speak a little bit on the impact of the project overall. So first of all, it laid really a good foundation for us to continue advocating for pro bono engagement in Rwanda, because we were able to work with, again, law firms and private lawyers. It also, they're helping us in, for lack of better word, like spread the word, because it was not something that was talked about before. But with this project, they were more and more exposed, and we think it laid a good foundation for us to continue advocating on that. I also mentioned we did a lot of legal awareness activities, and we reached thousands of people, and it showed really the need and the importance of legal education among vulnerable populations. I will continue to stress, if people don't have their rights, then they cannot claim them. This is, yes, about partnerships with private law firms. I mentioned they did expand access to legal assistance. So if CSOs could maybe support, I want to say maybe 20 or 10 cases in a month, by partnering with law firms, they were able to take on more cases. They're able to take on, to help more people access justice. So it proved to be a very, very, very important kind of partnership for CSOs to be working with law firms. And of course, it also made significant contribution to strengthening the capacity of university legal aid clinics. I mentioned earlier that we had to work with law students to instill in them the culture of pro bono, and this was essentially just involving them in the activities of the project, and we were very happy to see that it's something they were excited about. So to conclude, I wanted to conclude with a very short call to action. So amidst this global justice funding gap, which justice is always underfunded, and shrinking civic space, and now even more declining development funding, it is really imperative to support these kinds of grassroots initiatives that sustain and can even scale up cost-effective approaches to justice, because these approaches and innovations are usually closest to people, and they're uniquely positioned to identify what needs they have and give them the appropriate specific, context-specific, but also culturally appropriate responses. But equally important, as I kept mentioning, is fostering this culture of pro bono within the legal profession, where law firms or even private lawyers can contribute their expertise to bridge this justice gap. So together, grassroots action and pro bono engagement, I think, can create a powerful complementary force that ensures access to justice for the most vulnerable. I will conclude my presentation here. Thank you very much.
Thank you so much, Ms. Leonie Mutoni, for sharing with us the impact that you have done in Rwanda, and I hope colleagues have been able to draw lessons from it. It's at this point that we get to the question and answer series, and I see we already have questions. One is directed to Patrick from Cecilia Rutembesa. They ask, what strategies could better encourage commercial law firms and private lawyers to embrace a pro bono culture, given the challenges they face in getting them to provide such services and of quality? The second question is open. I guess Shirly or Leonie would take it up. David asks, how can partnership enhance access to legal information and resources in Africa to support legal research for judges, lawyers, magistrates, and the general public? David is from the judiciary of Sierra Leone. And the third says, in some African countries, there is need for legal aid fund. What advice do you have on this type of fund? This legal aid fund can be non-state, state, or mixed funded. Somebody from Rwanda is asking. I guess Leonie would be able to speak to this. So Shirly, you take David's question. Over to you, Patrick.
Thank you, Joseph, and thank you, Cecilia, for that really important question. And it is true that, and as Leonie has indicated, the context in Africa, we found that there is always the interchange of the word legal aid and pro bono, and legal aid having traditionally been focused mainly on court representation of people that could not afford, legal counsel. Then the question begs, how does a commercial law firm engage in pro bono? In fact, one of the conversations we've had with many law firms is when they indicate that, yes, they used to provide pro bono, but now in the context of their corporate practice, they no longer provide pro bono. And I think for me, one of the strategy we've adopted and core part of our work as FYD is to engage the legal community, especially the national bar associations and the commercial law firms, in promoting the culture of pro bono and having peer-to-peer learning, particularly with the global leading law firms, so that they can be able to demonstrate how, as a leading commercial law firm, they deliver pro bono, because many of the leading global law firms have active pro bono programs. So in addition to this, one of the strategies we've adopted in the past has been organizing a pro bono roundtable for lawyers and civil society organization, because we did realize also that often the commercial law firms and the CSOs that would need these pro bono legal services speak in different languages, although they're speaking to the same need. And moving forward, I think it's for us, even as civil society organizations and national bar associations and commercial law firms, to have more conversations around what is pro bono in our context, in the context of our countries. I know currently we are contributing to development of East Africa pro bono guidelines, and I think that will also help so that we can provide a context in which different law firms, including in-house counsels, can be able to understand where do they plug in. And at FYD, that is the main work done by our pro bono legal services team, who are able to support CSOs, grassroots organizations, and NGOs to be able to curate their requests in a way that can be understood by corporate law firms. And at times, pro bono could include reviewing a contract or supporting with a registration of a nonprofit or helping with a legal checklist. So I think moving forward is to have those conversations more between the civil society organization and commercial law firms, so that we can speak in a language that all of us understand. And again, another strategy to engage more with the national bar associations, so that we can have guidelines that different sectors of the legal community can understand how they can plug in developing and promoting the culture of pro bono, and also being able to use the areas of expertise to provide pro bono legal assistance where it is most needed, particularly by grassroots communities, NGOs, social enterprises, and those that otherwise will not be able to afford these legal services if they were to approach a commercial law firm for such support. So feel free to reach out to us. Our pro bono legal services team should also be able to help. That's what we do in our pro bono brokerage, to be able to curate this request in a way that commercial law firms can be able to respond to. I'll also highlight briefly on the second question from David. And thank you, David, for that question. I wanted to highlight that one of our programs, which is the FYD Rule of Law Expertise Program, promotes partnerships between stakeholders in Africa in the rule of law sector, and our counterparts, particularly in the UK legal and judicial sector. I know that our Role UK program has supported initiatives to support libraries and sourcing of resources for judiciary libraries. I will provide you contacts to our Role UK program team, and they should be able to have a conversation on how could you leverage on the work they do in supporting rule of law strengthening to identify opportunities where the judiciary in Sierra Leone could be able to have access to resources or library resources. Again, building on partnerships between stakeholders, both in the UK and other jurisdictions and in Africa. Over to you, Joseph.
Thank you so much, Patrick, for expounding on the questions and being able to give an exhaustive response. Shirly, do you want to make comments on David's question, or you're fine?
I think Patrick has answered it, and just to add, I agree with him, because partnerships can play a very big role in enhancing access to legal information and resources in Africa. And there's that need for pooling that expertise, technology, financial resources, so that to ensure that this is done. So I think the answer to the question would be digitalization and open access. So I know we do have sources that have this information specific to different countries. So for instance, in Kenya, we have the Kenya Law Reports, and then we have the regional databases, for instance, the AU, ECOWAS, and, Africa, what is it called? Africa Legal Information Institute. So maybe either we can use those platforms individually, or think about the innovative ways that that we were talking about, and having whether it's working with a tech company to ensure that all this information can be found on one platform, to make it easier for, if I want information on all African countries, I can get it on one platform. I don't necessarily need to go to Kenya Law Reform for Kenya, something else for Rwanda. So I think that is what I can say in that regard.
Thank you so much, Shirly. We will now move to Leonie to respond to the third question.
Sorry.
Should I recap the third question?
No, it's okay. I saw it. I actually wanted to briefly add on to the very good points by Cheryl and Patrick with regards to David's questions. I just wanted to share an example on how partnership can enhance access to legal information. And this is something that we have also done at the Legal Aid Forum. So for example, if a government can publish a law, I think there's many ways that this partnership can really work. So for example, if a government can publish a law, let's say universities and researchers can provide, say, analysis and commentary on said laws. Civil society can translate, say, complex legal text into accessible formats for the general public, which is something that we do a lot. While law firms can also contribute through provision of pro bono legal services. So I just wanted to share that example. And for Gachire's questions, it's funny because I think maybe someone else can answer it, maybe Cheryl, because I know that Kenya, for example, has a legal aid fund. So the question he's asking, we're from the same country. We've been advocating for Rwanda to have a legal aid fund for a long time, and a legal aid law as well, because I mentioned earlier that so far it's civil society organizations that are mainly providing legal aid services. So we have been advocating for this, and one of the biggest pushbacks that we get is, of course, resources. Government always has competing priorities, but it's not that there is lack of political will. So we're finding different ways to go about it, but I would be very happy to hear from Cheryl, maybe what Kenya's journey was like when to get legal aid to be funded by the state, or any other of participants who would like to share. I just specifically knew about Kenya because we also tried to do kind of a study, like a benchmarking study on legal aid systems in Kenya, and we were impressed that you are so much more progressive than us in that area. So if there's anything you can share to that end, it would be much appreciated. Thank you.
Ali, do you want to pick it up to share Kenya's experience?
Yes. So yes, in Kenya we do have the National Legal Aid Service, which is a state agency, therefore state funded. I don't know if they would share your sentiments, because they always say they do not have funding. But I will say, because, for instance, the National Legal Aid Service, it is state funded, yes. And as you're saying, there are competing government priorities, so they may not receive the funding they need. However, they also receive funding from donors, for instance, through EU, through the PLEAD program. So for me, I believe that what we're saying, partnership, so we can have a mix of both, the state funding as well as the non-state funding from either donors or civil society, to ensure that the work still goes and does not stall because there's no state funding. CSOs, for instance, if you look at FIDA, they have their own, say, pro bono network, where they have pro bono advocates and they pay them as a civil society. So I think it's, again, the issue of partnership, collaboration between our various institutions to ensure that the pro bono service is running, because it is necessary and it is essential in all countries.
Thank you, Shirley, for those remarks. And speaking of sustainability of this great work, this is a question to all of you, with Patrick inclusive. With the situation of funding challenges worldwide, the changes you've made mention of, are you confident that the work that you're doing will continue to exist?
Okay, maybe I'll go first. It's a very tough question.
It's a very tough question, but
yeah, and I can try to speak from the experience of the Legal Aid Forum, because we did have a big USAID project that had to be terminated effective immediately from the letter that we got. But so I think, first of all, as a non-profit, non-governmental organization, it is very difficult to say that you can survive without some kind of funding, because if you're not selling your services, that means you must be fundraising the money from somewhere else, right? So our focus has been now to invest more in cost-effective, people-centered approaches. And I will share, for example, community-based paralegals. So we work with community-based paralegal who, like prison-based paralegals, don't necessarily have, let's say, have gone to law school or any of that, but they have received trainings. The Legal Aid Forum has trained paralegals. We actually work with about 30 paralegals who are stationed all across the country. We have 30 districts, and each district has a paralegal based there. So what we do with these paralegals is that we train them on key laws and also on legal aid performance standards, and they work on kind of like volunteer basis. But they do so much work. They are giving legal advice in communities. They are resolving issues before they even get to court, which is amazing because we are trying to promote ADR. We have issue of case backlogs. So community-based paralegals is an initiative that it does need funds to run, but it's like very, very cost effective. Another thing that we do, another approach that we have, for example, is our legal aid call center, which people can access remotely from wherever they are in the country. And all that LAF has to do is maybe we have to pay telecommunication companies. It used to be a lot more expensive before, but with the support of FOID, for example, we're able to shift the call center on our own servers so that we don't have to pay a third party to host content and stuff like that. So what we do now is basically to pay telecommunication companies for airtime, because we want people to be able to call us for free. So that's another initiative. Again, it requires money for sure, but it's very cost effective and it's scalable. So just to answer your question, again, it's hard to say that without funding, you're going to keep going forever. But I'm also happy to share that we have these initiatives that can continue to give people the access to justice that they need without them necessarily requiring too much funding. I hope that makes sense.
Thank you so much, Leonie. You've expounded on it. It's just a worry that crossed my mind. You know, we're talking about all this good work, but then the reality on the ground is that funding is dwindling. So we need to be able to see how best to deal with it. And I'm glad that your responses speak to the innovation that you're employing to deal with that looming crisis. I don't know if Patrick or Shirley have anything to add on, or they are associating with your submissions.
Yes, I think Leonie has well captured it, and it's true. They're changing realities in geopolitics and strain of resources, especially for the nonprofit sector. And for us as FYD, this is also an opportunity for, even as traditional structures of going to the corporate sector, to see what support the private sector could complement on what is missing from the development aid and overseas development assistance. Also to ask how can we leverage on partnerships as members of the legal community to step into the gap. Case in point, in Kenya, we have about 22,000 lawyers, and in East Africa, about 42,000 lawyers. I believe in terms of our access to justice, deepening access to justice and strengthening rule of law, if we're able to leverage and innovate new ways of engaging with particularly commercial law firms to provide pro bono legal assistance for organizations so that they can be resilient and be able to survive this phase and entrench sustainability in their operations. I believe it is possible for us to leverage on the legal community as part of the innovative strategies to bring additional stakeholders to cushion non-profit organizations and community-based organizations on the financial challenges they are likely to face in the coming days, so that we can ensure access to justice despite the disruption remains a reality for communities.
Thank you so much, Patrick, for sharing more on how best we can deal with this crisis. And I'm going to extend my appreciation to Shirley and Leonie for their insights. The session has been extremely informative. There is so much to affirm that partnerships are the only way for us to be able to achieve the justice we need on our continent. I see we are already a few minutes past the top of the hour. I'm going to invite Yasmin to be able to give us the closing remarks for our session. Yasmin, over to you.
Thank you very much indeed. So as we draw this session to a close, I'd like to thank all our excellent speakers and also our moderator for their inspiring contributions. But I want to take a moment to reflect on the insights and ideas which have been discussed today. We began this webinar with a belief that the law and the legal profession are a force for good, a tool for justice and a pathway to sustainable development. And throughout our discussions, we've seen that this belief is brought to life. Together, we have explored the many different roles that each of us can play and how, when joined in partnership, these roles can lead to outcomes that are not only impressive, but transformative. We've seen how partnerships deepen access to justice, advance equity and human rights, strengthen the rule of law, and empower communities to thrive. We heard from Shirly, who reminded us that even though the most entrenched legal issues, such as the death penalty, can be reformed, Shirley's reflections showed us that legal reform can offer hope, restore dignity, and create an environment where justice is truly accessible. Leonie, who admirably stepped in at short notice, inspired us with an example of, and I quote, partnership in action. She also spoke about how innovation and simple mobile technology can open the door to justice for millions who are too often excluded, the underprivileged, the marginalized, and the indigent in our community. And Patrick spoke eloquently about A4ID, focusing on our work in Africa, emphasizing the importance of partnership working. Taking together, these discussions have underlined, I suppose, one crucial message. Partnerships are not optional, they are essential. And I think also, Joseph, the question you asked regarding funding also addresses that. Partnership working is essential to ensuring the longevity of all organizations based on their working together and collaborating. Strengthening the rule of law is a shared responsibility after all, and a necessary step if we are to achieve sustainable development. But perhaps the most inspiring message of all in this is that each of us has a role to play. Lawyers, civil society organizations, business leaders, policymakers, we all have the power to make a difference. Whether through pro bono legal support, advocacy, mentoring, or partnership building, every action we take can amplify justice, equity, and sustainability. So the question is not if we can make a change. The question is how boldly we will step forward to do so. So as we leave this session, I encourage you to carry on in the spirit of today in your work. Build partnerships that matter. Stand up for justice. Use your expertise to protect rights and create opportunity. And share your influence, your skills, your knowledge, and your compassion. Together, we can ensure that the law is not a barrier, but a bridge to opportunity, dignity, and a future that is fair, sustainable, and inclusive for all. Now, I'm going to conclude by saying, please fill in the short questionnaire that's accessible in the chat. And I hope you will join us again tomorrow for the final session in this webinar series. Tomorrow's discussion is about bridging the gap, legal expertise for lasting social change, this time in South Asia. It promises to be an equally thought-provoking conversation. So on that note, I thank you again for joining us. Thank you for your questions, and I close this session. Thank you.
Thank you.
Thank you.